For all districts, and we are very, very fortunate today to have Lisa Palmer from our BOCES come and help with this training. I'm not qualified, we don't have a qualified person in our district, and I know Lisa has been running from district to district, so I'm very grateful she could come for our conference day this morning. And so this, again, is required. We're videotaping it to put it on our website and for everyone who's not here today, but Lisa, thank you for coming.
Thank you for having me. It's a hard act to follow. I do not have any days to tell you that you have off, so so obviously we'll start with the theme of the day with wellness. This is a harassment prevention training, and Britta did a nice job of just kind of giving you a little preview as to what the requirement is. As you may be aware with the news and media, there has been a newfound awareness of sexual harassment recently, giving our state the ability to make some amendments to our requirements and to laws. And one of those pieces has to do with the requirement for school districts. So the new requirement for school districts that was put into place in the fall was that school districts needed to revise their harassment prevention policies and include specific language in regards to sexual harassment. The districts had to have those policies adopted at the October board meeting in the fall. And then there is a training requirement for all staff, that all staff has to be trained by next October, or October 2019, and then it is an annual training that will happen. We're working with districts and we're working with our attorneys as to how that will look, because obviously there's a lot of mandated trainings, and we want to ensure that the message is out there, that people understand what the policies are and what the law is, but we also want to make sure that we are allowing districts to have those mandated trainings, and it's not just a day full of those training informations. So my name is Lisa Palmer. I'm the Director of Personnel Development and Improvement at the BOCES. One of my roles is internal personnel, but I also work with districts on different compliance and trainings and mandates in accordance with different personnel items. So the goal of today's training is to, again, make you aware of some of the changes within the law, make you aware of your policy revisions, and then also making sure that you know exactly what the reporting procedures are within your district, and there are some external reporting procedures as well, with the main goal to make sure that you maintain a safe, positive working environment, that everyone feels safe and comfortable coming to work. So again, goes right in with that wellness theme that you have for today. So what is harassment? Harassment can mean a lot of different things to a lot of different people, depending on perceptions and experiences that you've had. But ultimately, it's a form of discrimination, and it's unlawful. When we go through this training this morning, you're going to hear the word discrimination and harassment. Those terms, in accordance with the law and policy, are synonymous. So harassment and discrimination, as you hear them, mean the same thing, okay? Ultimately, when we talk about the law and the policy, harassment is on the basis of sex, sexual orientation, self-identified or perceived sex, gender expression, gender identity, and the status of being transgender. These are those protected classes that you're going to continue to hear me say throughout this training. When we talk about the law and the policy, these protected classes are the ones that we are talking about that are protected under the law and the policy. Anything outside of those protected classes, although they're not protected under the law and the policy, that doesn't mean that it's not important. So if you feel that you are being harassed or you feel that there is an uncomfortable situation, please make sure that you let your administrators know, because they want to ensure that you have a safe and positive work environment. So although it might not be protected in your policy or by the law, it's still important to your district to ensure that whatever is going on can be handled and rectified so that you feel safe coming to work. As far as sexual harassment, again, this is the piece that was really added to the law. It is any unwelcomed conduct, and there are certain slides that I do have to actually kind of go through line by line based on the mandates of the training, so I apologize. I'd like to make this a little bit more interactive, but there are some pieces that I do need to make sure I outline. But ultimately, sexual harassment is unwanted conduct, either of a sexual nature, which is directed at an individual because of that individual's sex, okay? And ultimately, it has the purpose or effect of unreasonably interfering with work performance, okay? Again, this is where it comes into perceptions, okay? Perceived, what is happening, what the individual is perceiving happening, or let's say there's interactions between two colleagues that someone else is witnessing and that individual is feeling just not good about it, okay? So even if those two individuals that are engaging in whatever activity or ever behavior is happening, there may be individuals that are witnessing it that feel uncomfortable about it, and they are well within their rights to feel that way, okay? Such conduct that's made either explicitly or implicitly, okay, when it comes to a term or condition of employment, and then submission or rejection of such conduct is used as the basis of an employment decision, and we'll talk a little bit about some examples of that. A hostile environment is also something that is protected in the policy and in the law. And this is pretty much any sexual or discriminatory displays or publications anywhere in the workplace, okay? So in your office space, okay, in your classroom, in a break room, in a faculty room, on your computer. Let's say you have a screensaver that's on your computer that happens to just be in the background of your computer, and someone comes into your workspace and finds that it's offensive, okay, then they could actually go forward and say that there's something that makes them feel uncomfortable. Hostile actions taken against an individual because of that individual's sex, okay? And again, going back into those protected classes, right? So these are some different categories that are clearly outlined in the law and in your policy. And the gray box, I want to just bring your attention to it, that talks about the reasonable person standard. The reasonable person standard is what governs whether or not something is harassment in accordance with the law and the policy, okay? And when we talk about that reasonable standard or that reasonable person, it would mean that would someone with that has a reasonable understanding find that behavior offensive? So when an actual complaint comes forward and it is investigated, that reasonable person standard would be what would be governing whether or not harassment actually occurred within the policy and the law, okay? So some examples of harassment would include the physical acts, that would be touching, pinching, kissing, patting and hugging, or poking against another employee. Altering a work environment that creates an intimidating or hostile or humiliating environment against those protected classes. So we talked about computer screensavers or posters that you print out and put up on your wall that someone might find offensive. Sexual discriminatory displays on computers or cell phones, or sharing those displays in the workplace, okay? Sending an email to a colleague, okay? That maybe contains a joke or something along those lines, and that person finds it extremely offensive. Or let's say it wasn't intended for someone and someone else got their hands on that joke and they find it very offensive, okay? Text messages is another one, okay? And we'll talk a little bit about making sure that you're using, your best professional judgment when interacting with individuals through text messaging and email. Sexual-oriented gestures, noises, remarks, jokes about a person, whether it's about their sexuality or sexual experiences. Bullying, yelling, name-calling based on those protected classes. And then sabotaging an individual's work, okay? Whether you're sabotaging their work tools or terms of conditions of their employment or any equipment that they may need. Quid pro quo sexual harassment is another form of harassment, and this is ultimately when a person in authority trades or tries to trade job benefits for sexual favors, okay? Oftentimes it occurs with someone that's in an authoritative role and has the ability to grant or withhold any sort of job benefits from that individual, if they don't. So this for that type of mentality. When we're talking about who's protected under your policy and under the law, who can be targeted? It's ultimately anyone that is associated with your district that is paid or unpaid that would be interacting with each other. So obviously, the obvious examples would be colleagues, supervisors. Some of the less obvious would be consultants that come into your district, vendors. Let's say you have your capital project and you have individuals that come in to do some of the work for the capital projects. All of those individuals that are paid and unpaid would be protected under your policy and under the law as being targets if they fall under the protected classes. And that's the same thing for perpetrators. It's anyone in the workplace that is associated with your district that is paid or unpaid. It can be coworkers, supervisors, but it also can be those third-party individuals, okay? Interns, vendors, consultants, anyone that comes in contact with anyone within your district. Where it can occur, again, the basic, the locations would be within your actual campus. So in your buildings, on your field, on your buses. Some of it, the little bit more outside the box places would be, let's say 2 colleagues attend a conference somewhere off-site. That could be a location where it would be governed under your policy, okay? Let's say office parties. Where it gets even more complicated is when text messaging, social media, emails are involved, because any place that 2 individuals can communicate via those vehicles would be a location that would be protected under your policy. Okay, so be very mindful about what you're sending. Make sure that you're using your best judgment prior to sending anything that might be offensive to individuals. Sex stereotyping is another piece that is outlined within your policy and the law. And this is harassment based on that a person doesn't conform to either gender stereotypes or different types of jobs that may have traditionally been performed by one gender and is now being performed by someone of the opposite gender. We have a case study to make it a little bit interactive that kind of talks a little bit about sex stereotyping to kind of outline it. So in this case study, we have Carla. Carla works as a licensed heavy equipment instructor. As you know, the BOCES has CTE programs, and so oftentimes we have different programs that have heavy equipment. So Carla is a licensed heavy equipment instructor, and some of her male coworkers think it's fun to tease her. Carla often hears comments like, "Watch out, here she comes, that crazy woman driver," in a joking manner. Also, someone keeps putting a handmade sign on the only porta potty at the work site that says "men only." Question 1, women in traditionally male jobs should expect teasing and should not take the joking comments too seriously. True or false? Correct. Whether Carla is being harassed depends in part on Carla's opinion of the situation. So we talked about that perception. That is whether she finds behavior offensive or not. However, if at any part Carla feels harassed, so let's say she's okay with it in the beginning, and then all of a sudden down the road she decides that she's had enough, she has the ability to speak up at that point, even if she was okay with it in the beginning. So at any point, she can actually speak up and say that she now feels harassed or feels uncomfortable. Question 2, Carla cannot complain because the site supervisor sometimes joins in with the joking behavior, so she has nowhere to go. True or false? Correct. Carla can still complain to the supervisor, who is then on notice that the behavior bothers Carla and must be stopped. And I'd obviously want to have a conversation with that supervisor about why that supervisor is joining in on this type of behavior. The supervisor's failure to take Carla's complaint seriously constitutes serious misconduct on his or her part. She can complain directly to that person, or she can also talk to any of the designated individuals, the compliance officers, and we'll make sure you know who the compliance officers are in your district, to receive any of those complaints. The employer is responsible for assuring that all employees are aware of the anti-harassment policies and the procedures that are outlined within that policy. Some of Carla's other coworkers are strongly opposed to her presence in the traditionally all-male profession. These coworkers have sometimes said things to her like, "You're taking a job away from a man that deserves it, you should be home with your kids, and what kind of mother are you?" Also, someone scratched a really nasty word in Carla's toolbox. These behaviors, while rude, are not sexual harassment because they are not sexual in nature. True or false? Correct. Remember, we talked about those protected classes, okay? And Carla, being a female, would be protected under those classes. So these behaviors are directed at her because she's a woman and appear to be intended to intimidate her to cause her to quit her job. So they are well within the policy protections. While it's not sexual in nature, this harassment is not okay because of her sex, and it could create a hostile work environment. So that brings us to, what should you do? What are the vehicles, what are the outlets that you have to protect yourself? First off, there is a complaint form, which I'll show you in the next slide. And that complaint form would be completed and forwarded to her compliance officer, which Jen Hall is your compliance officer. But also the building principals are also outlined as being compliance officers within your policy. So any of those individuals can receive complaint forms. The district encourages you to use that actual formal written complaint form. However, they will also take verbal complaints, and then they will walk you through the steps of how to make sure that all of the information has been gathered. This is the complaint form, which I see as a kind of flying in the air, but this is the complaint form for both student and employee complaints that would be completed and then submitted to any of those compliance officers that we just spoke to. This complaint form, or this procedure, can be used for if you feel like you're being harassed, or if you feel like you've witnessed some sort of behavior that could be harassment, okay? We encourage you, I know how hard it could be, but we encourage you to please report any sort of concerning behavior to the administrators, or so that they can ensure to investigate and make sure that it is rectified and people feel comfortable and safe. Once a complaint form has been received, then we would obviously make sure that the investigation begins immediately and is completed as soon as possible. Because obviously it could vary in severity, but we want to ensure that individuals feel comfortable and that there is not a long, prolonged time that goes by. The investigation will be kept confidential to the extent possible. And the reason that we put a little asterisk by that, oftentimes when you're investigating something, sometimes other individuals may be called in as witnesses or to be interviewed to gather any information that they might have. So although you might be the individual that brings forward the complaint, other individuals may need to be called in to gather some additional information to ensure that a thorough investigation can happen, okay? Any employee that is asked to cooperate within an investigation, we ask that you do cooperate so that we can ensure that the situation can be handled and thoroughly investigated and obviously rectified. So the compliance officer would conduct that immediate review of the allegations, and some interim actions may have to happen while the investigation is happening, okay, depending on what the nature of the complaint was. Relevant documents may be asked for, so that it could include phone logs, emails, any sort of correspondence that may have occurred. Interviews would be conducted with any of the individuals that might have information pertaining to the complaint. And then the individual that complained or have been accused will be notified of the final determination and so that they know that the administrative action has been taken. Your policy and the law also protects against retaliation. And ultimately what that means is that any individual that engages in any of the protected activities of either making a complaint about harassment, providing information during an investigation, or testifying in conjunction with a complaint. Those are the Thank you. New technology. Any of those three protected activities would be the ones that would be protected by law for retaliation, okay? So some examples of retaliation would include any actions that would alter an employee's terms and conditions of employment because they actually engaged in one of those protected activities. So that could be a sudden change in work schedule or demotion or bribes because they actually participated in one of those protected activities. However, just because someone participated in those protected activities doesn't mean that you are not bound to the policies that the district has in regards to what your responsibilities are in your role, okay? So ultimately, supervisors are still going to be supervising no matter if you have engaged in one of those protected activities or not, okay? You're still subject to all job responsibilities and policies. So an example of that, let's say that your supervisor has had continuous conversations with you about coming to work on time, okay? And you've had numerous conversations over a series of, weeks or months, and then there is a harassment complaint that is filed by you, okay? It's investigated, things are looked at, you get the final determination as to how it happened, what happened with the situation. And then 2 days later, you come in late and your supervisor calls you in to talk to you about coming in late. That would not be retaliation because your supervisor has had conversation with you about your responsibility of coming to work on time well before you participated in filing that harassment complaint, okay? So you're still bound to any of the policies or your responsibilities as an employee, even if you engage in those protected activities. It's those other pieces that we talked about, whether or not it's the terms and conditions of your employment that have been altered because you actually engaged in those activities. That would be retaliation, okay? Outside of the policy and the law, there are also some external protections for you that we like to make sure that you are aware of, so that you don't need things that you don't even have to report within your actual district. We encourage you to make sure your district is aware if something is happening here, because obviously they have firsthand knowledge to be able to help problem solve whatever is occurring. The first piece is a complaint can be filed with the Department or the Division of Human Rights. It can be filed with DHR anytime within 1 year of the alleged sexual harassment. You do not need an attorney to file, and there is more information on the website there, which is also outlined on your policy. You also have the EEOC. An individual can file a complaint with the EEOC anytime within 300 days of the alleged sexual harassment. You do not need an attorney to file this means either. A complaint must be filed before you can file in federal court, and there is more information at the website that is given at this site as well, and it's also outlined in your policy. There is also the U.S. Department of Education, which is their Office of Civil Rights. You can get more information on how to file a complaint with the Office of Civil Rights at their website as well. And then, of course, any of your... That was a short one. It actually gives me a second to catch my breath because I usually talk too fast. Many local law enforcement agencies are also available. If there is at any time something that occurs that you feel may be constituting a crime, we encourage you to ensure that law enforcement is made aware, okay? So that would be physical touching, coerced physical confinement, or sex acts. Please make sure your local police department is aware so that they can investigate it on their end, as well as the district would be able to make sure to provide any information that they might need. So to summarize, we want to make sure that you know exactly how to utilize your policy and the complaint form within your district to bring any information forward that you might have you might not feel comfortable about different behaviors. We want to make sure that you know exactly how to do that. We want to make sure that you know where your policy is located. Your policy is located on the website, so please make sure, I encourage you to actually read it, because this is just a summary of some of the main bullet points from the policy and from the law. We want to make sure that we encourage you to report anything that is suspicious or makes you feel uncomfortable. And ultimately, we want to ensure that you have a safe and positive work environment, okay? So please make sure that you go to your building principals or to Jen if you have any concerns at all. And that is the policy number for you and the admin reg. Questions at all? Okay. All right, thank you very much for having me. Involved in or protected under the policy. So that would be something that you would definitely want to make sure your administrators know, and you would have to work that out with your administrators as to what problem solving skills can be put in place, whether it's having a colleague present when you're actually meeting with those parents or whatnot, or having different vehicles and how you would communicate with that parent. But ultimately, yes, parents are not covered under the policy. But great question, because that is not the first time that we've received that. Any other questions?
I get the same question in DASA training every time.
I know.
Yeah.
It's a hard one.
Thank you so much, Lisa. I appreciate your travel to Galway, and thank you. Yeah. Okay, also required annually is DASA, and I'm trying to pick parts of DASA. We have talked about verbal, social, physical, and cyberbullying.